This is Bloomberg Law with June Grasso from Bloomberg Radio.
How can I return him to the United States? Like, I smuggle him into the United States, or what do I do? Of course, I'm not going to do it. It's like, the question is preposterous. How can I smuggle a terrorist into the United States? I don't have the power to return him to the United States.
So you can release him inside El Salvador?
Yeah, but I'm not releasing, we're not very fond of releasing terrorists into our country.
The president of El Salvador, Nayib Bukele, said in the Oval Office today that he would not return a man who was wrongfully deported to his country. This was backed up by U.S. Attorney General Pam Bondi's seemingly incorrect interpretation of the Supreme Court's order that the Trump administration facilitate Kilmar Abrego Garcia's release from custody in El Salvador.
That's up to El Salvador if they want to return him. That's not up to us. The Supreme Court ruled, President, that if, as El Salvador wants to return him, this is international matters, foreign affairs, if they wanted to return him, we would facilitate it, meaning provide a plane.
And Secretary of State Marco Rubio basically said there's nothing to see here, even though the issues in the case have been litigated all the way up to the Supreme Court and are now back before a federal judge for another hearing tomorrow.
I don't understand what the confusion is. This individual is a citizen of El Salvador. He was illegally in the United States and was returned to his country. That's where you deport people, back to their country of origin, except for Venezuela that wasn't refusing to take people back, or places like that. I can tell you this, Mr. President, no, the foreign policy of the United States is conducted by the President of the United States, not by a court. And no court in the United States has a right to conduct the foreign policy of the United States. It's that simple. End of story.
No one in the Trump administration mentioned that Garcia was not given due process before he was deported and that there was a court order forbidding his deportation to El Salvador. Joining me is Bloomberg legal reporter David Voreacos. David, start by telling us who Abrego Garcia is and how he ended up in an El Salvador prison.
Abrego Garcia is a migrant from El Salvador who lived in Maryland outside of Washington. He has a wife and 3 children who are U.S. citizens. He had been working as a day laborer. He had been picked up by immigration authorities in 2019, and they said in proceedings that year that he was a member of MS-13, which is a criminal gang. Abrego Garcia and his attorneys steadfastly denied that. What's clear coming out of those 2019 proceedings is that an immigration judge ruled that he could not be deported to El Salvador because he would be subjected to persecution and extortion by another criminal gang. And so that meant that he could not be sent lawfully by the United States back to his native El Salvador. So skipping ahead, in the middle of March, he was picked up by U.S. immigration authorities who said that he was an MS-13 member. And at that point, the Trump administration had said that MS-13 is a foreign terrorist organization. And they now interpret that to mean that they had the authority to remove him from the United States back to his native El Salvador, where he was flown on March 15th in one of 3 planes with about 250 alleged gang members, and is now staying in a notorious prison in El Salvador.
So let's skip the lower court and just go right to the Supreme Court ruling, which Trump advisor Stephen Miller, I would say, wrongly characterized the Supreme Court ruling as being in Trump's favor, 9-0. So explain what the Supreme Court ruled unanimously last week.
On April 10th, the Supreme Court said that the Trump administration needed to take steps to bring back Abrego Garcia because he had been wrongly deported. And that is, in fact, something that the Justice Department admitted, that he was wrongly deported because of the 2019 ruling that he could not be sent back to El Salvador. And so the Supreme Court said that the government needed to facilitate his release from custody in El Salvador and send it back to the district court judge in Maryland to work out how to facilitate this return. The judge has asked for daily updates since then from the government on how they were going to facilitate this return, and the Trump administration has been silent on that question, has not said what they were doing. And it became clear Sunday night and on Monday what their real intention is, and that is that they don't believe that the Supreme Court ordered Abrego Garcia returned to the United States, and they don't believe that any U.S. courts have the authority to dictate foreign policy. They believe this is a question of foreign policy and that it's up to the El Salvadoran president, Bukele, to decide whether to send him back to the United States. And Bukele answered that definitively today from the Oval Office.
So we saw this remarkable tour de force in the Oval Office where you had President Trump, the Secretary of State Marco Rubio, you had the Attorney General Pam Bondi, the Vice President, basically saying that they don't have to return him, that it's up to El Salvador.
Right. And the El Salvadoran President Bukele said he can't send him back. He doesn't have the power to return him to the United States. He said, how can I return him to the United States? I smuggle him into the United States. I'm not going to do it.
This is such an unusual situation because the man who was wrongfully deported is actually a citizen of El Salvador. If he was a Venezuelan, it would be a different story. But now he's actually back in his native country.
Right. That gives more force to the Trump administration argument that he's an El Salvador citizen and that the president cannot send him back to the United States. But the question was he wrongly deported from the United States originally because of this 2019 order that said he couldn't be sent there?
It doesn't appear that the Trump administration has asked El Salvador to send him back, or that they intend to ask El Salvador to send him back.
They put it to the Salvadoran president point blank in the Oval Office today, will you send him back? And he said no.
I mean, part of this, I think, is they're afraid that if they open the doors of the prison, let's say, to this one guy, that then they're going to have more and more people trying to use that as a precedent, saying, well, I don't belong here either. I mean, the vast majority of Venezuelans who were deported to El Salvador, to that prison, have no criminal record.
The immigration law, as I understand it in the United States, is stacked very much against migrants. And so the government has a great deal of authority to deport people. The cases that have reached the Supreme Court were unusual variations from that law, the one involving the Alien Enemies Act, which is not the normal immigration law that the United States uses, and this one where a migrant said that I have a specific order that says I cannot be sent, and so he was denied his due process. I think the Supreme Court is not necessarily saying the Trump administration cannot use regular immigration laws to deport people. It's just that they have to give due process to everyone they deport.
Tomorrow, there's going to be a hearing before the federal court judge. And last Friday's hearing was also kind of remarkable because they wouldn't even tell her where he was at the time. Now we do know they've confirmed, right, that he is in the El Salvador prison.
Correct. They wouldn't tell her where he was. They told her over the weekend that he was alive and in that El Salvador prison that's built to hold terrorists, as the Salvadorans would say, but they won't say what they're doing to try to return him. And this judge has had very harsh words for the Justice Department in its handling of the case. So one has to assume that she won't be pleased with this turn of events at the hearing on Tuesday.
So, I mean, it seems like this could go back to the Supreme Court. Has she issued a ruling since the Supreme Court handed down its decision?
She has not. The Supreme Court returned it to her to essentially work this out under their ruling, and she's trying to do that and asking the Justice Department, what are you doing to comply? And now we know their answer is we don't believe we have to comply. So it's possible she could cite people from the Justice Department for contempt or the Department of Homeland Security. It's also possible that the plaintiffs in this case, Mr. Abrego Garcia's lawyers, might go back to the Supreme Court. This is a very unusual situation, and it's hard to know how it's going to play out.
That hearing tomorrow will be very, very interesting, and I know you'll report back to us on it. Thanks so much, David. That's Bloomberg legal reporter David Voreacos. Coming up next on the Bloomberg Law Show, 35 years after they were sentenced to life in prison without the possibility of parole for murdering their parents, the Menendez brothers have a chance to be released. But the L.A. District Attorney is fighting against their release, saying they haven't taken responsibility for their actions. I'm June Grasso, and you're listening to Bloomberg.
Today was actually probably the biggest day since they've been in custody.
This is a critical week for the Menendez brothers. 35 years after they were convicted of shooting their parents to death in their Beverly Hills mansion and sentenced to life in prison without the possibility of parole, they're getting a chance to argue to a judge that they've been rehabilitated and should be released from prison. It comes after a hearing last week over the current L.A. District Attorney, Nathan Hochman, trying to rescind the prior district attorney's request that the brothers be resentenced.
While the Menendez brothers persist in telling these lies for the last over 30 years about their self-defense defense, and persist in insisting that they did not suborn any perjury or attempt to suborn perjury, then they do not meet the standards for resentencing.
The brothers joined last Friday's hearing by Zoom as prosecutors displayed graphic photos from the crime scene, taking hours to paint them as serial liars. The Menendez brothers' attorney, Mark Garagos, called DA Nathan Hochman a 90s Neanderthal for his dismissal of the allegations of sexual abuse in the case. But at the end of the hearing, Judge Michael Jessic denied the DA's request, and the resentencing hearing will go forward on Thursday and Friday. Garagos called it the biggest day since the brothers have been in custody.
Justice won over politics. It's been a long time coming.
My guest is L.A. trial attorney David Ring, a partner at Taylor Ring. With this fighting between the current DA and the former DA, have the Menendez brothers become sort of like a political pawn?
In a way, yeah, they did. The backstory is that in Los Angeles, a few months ago, the district attorney was George Gascon, and the public did not favor him after his 4 years in office. They wanted him out, and he was very liberal and progressive. And he was the one who brought this motion for resentencing, that basically the DA's office wants Lyle and Eric Menendez to be resentenced, knowing that that would likely lead to them being released from prison. Well, George Gascon got defeated badly in the November election, and the new DA is Nathan Hochman, who's a tough-on-crime sort of DA, and he came in and reversed course and basically said, no, Lyle and Eric need to stay in prison for the rest of their lives. This was a cold-blooded murder, and I'm totally against them being released. So, yes, in a way, it's become a bit political.
Here, the district attorney, Hochman, is saying that they haven't admitted to the lies they told at trial, and so they haven't taken responsibility for their crime. So he wants them to say they lied at trial. Is that basically it?
Yeah, Nathan Hochman, the new DA, he's convinced, and many in the DA's office are convinced, that this defense, this self-defense that Lyle and Eric came up with back in their trials back in the 1990s was fabricated, that they weren't sexually abused at all, that they had absolutely no reason at all to murder their parents, and they did it for one reason and one reason only. That is for greed, for money, for their parents' inheritance. And so, he truly believes that, and he says the whole status of the case now is the Menendez brothers still making the same arguments they did 35 or 40 years ago, saying we were sexually abused. We obviously didn't have the right to kill our parents, but we felt like they were going to turn around and harm us in some way. And so Hochman and the DA is like, no, we're not buying that at all. And so that's really what it comes down to, is Hochman saying, these two convicted murderers haven't shown any remorse whatsoever. They're still making all these same arguments they made many years ago.
For resentencing, is there anything that says that they have to admit to their crime, or is it about whether they've been rehabilitated in prison?
Well, it's a little bit of both, because what's going to happen is, the Menendez brothers and their lawyers are going to come in and say, hey, we've been model prisoners, we've served our time, we were sexually abused, and people didn't really understand sexual abuse back in the 1990s and have a much better understanding of it today, which, is kind of a sympathy ploy. And, we're in our 50s, and we deserve to be released. We're not a risk to society anymore. Counter that to the DA, who's going to come in and say they've shown no remorse. This was a cold-blooded murder. These guys deserve to spend the rest of their lives in prison. They've shown no insight. They've shown no contrition. And basically, they're just saying the same things they did 40 years ago that didn't help them in their trial and got them convicted.
There was a hearing on Friday over the DA's motion to rescind the request for resentencing. And the prosecution, in a 3-hour presentation, showed the graphic crime scene photos.
They did do that, and look, let's face it, this is closely watched by the media and by the public, so there's a little bit of a dog and pony show going on in that courtroom. If this was just some run-of-the-mill case that no one was paying attention to, you probably wouldn't see that type of evidence or photographs like that produced in that type of hearing. But, they're playing to the media and the public a little bit, and they want people to remember how heinous and horrific these shotgun slings were. And so that's why they're trying to introduce the photos at the hearing the other day, and they'll absolutely, introduce all of that evidence again at this upcoming hearings.
What the judge said is there's no new information. None of this is really new. They've stuck with their story. It goes to whether they've been rehabilitated.
Yeah, and I don't want to get too technical. So the hearing from a few days ago, it was basically the DA, Nathan Hochman, was coming in saying, hey, I want to withdraw this motion that my predecessor, George Gascon, brought. I don't even want it heard. I want to rescind it altogether. And the judge said, you can't do that. Look, the DA's office brought it, and the DA's office doesn't get to change their mind just because a new DA has come in. So really, all the judge ruled on was this hearing is going to go forward. And really, what we're going to see at this 2-day hearing that's coming up, that's when we're going to see both sides really put on kind of a mini trial. One side saying the Menendez brothers deserve to be released, and the district attorney saying they absolutely don't deserve to be released. And so you're going to see a lot of arguments and a lot of evidence at this upcoming 2-day trial.
The Menendez brothers' attorney, Mark Garagos, framed this as the biggest win they've had since they've been incarcerated. Do you agree with that?
I do agree with that. It's a big win. The Menendez brothers have really exhausted almost all other avenues through the courts to be released. They've exhausted their appeals and their habeas corpus attempts and all that stuff. And so this resentencing is their best shot to get released from prison. And the fact that this judge is actually contemplating it and is going to hear arguments and evidence over it is a victory for them, because it puts them one step closer to getting released, or at least getting their sentence reduced so they get a hearing in front of the parole board. And so they're one step closer that they've never been before to having a good shot at being released from prison. So, yeah, it was a victory for Garagos and the Menendez brothers.
The Menendez family members were angered that the prosecutors showed those gruesome crime photos, and they claimed that shock over the photos sent the brothers' 85-year-old aunt to a hospital critically ill. The family member said the violent graphic display violated Marsy's Law, California's Bill of Rights for Victims, which states that victims are entitled to be treated with fairness and respect. And the DA apologized for not giving prior warning that there was going to be this graphic evidence. Most of their relatives support the release of the Menendez brothers and are none too happy with this new DA.
Well, it's interesting. Just like the public is wildly divided on this case. So are the relatives. You have a group of relatives who want Eric and Lyle freed, who think they've served their time and who think they had some sort of justification for the murders. And then you have at least one or maybe some more other relatives who are like, no, that was a cold-blooded murder and they should stay in prison for the rest of their lives. You have this polarization of this case, which is what makes it so fascinating, that makes this hearing that's coming up fascinating, as to whether or not the judge is going to decide whether he's going to reduce their sentence. And if he reduces their sentence, there's a very good chance they get out on parole.
They also have a request for clemency, and with the governor, that's another route out of prison if this doesn't work.
Exactly correct. They really have two paths to try to get released from prison. The one we've talked about already is this resentencing. Look, they were sentenced to life without the possibility of parole. So if they're resentenced and they're given, 40 years with the possibility of parole, well, they're eligible for parole. So that's how they get out. That's path number one. Path number two is California Governor Newsom can grant them clemency, meaning basically on his own he can say, I'm reducing your sentence to 30 years with the possibility of parole. And that's their other avenue for getting out if the resentencing fails. If you're reading the tea leaves, it looks like Governor Newsom might be leaning in that direction to maybe grant them clemency if they don't get resentenced.
And once again, that resentencing hearing will take place on Thursday and Friday. Thanks so much, Dave. That's David Ring of Taylor & Ring. I'm June Grasso, and you're listening to Bloomberg. According to a class action lawsuit, Weight Watchers websites allegedly shared users' personal information, including health-related data, with third-party tracking services like Google, Facebook, and Amplitude. Several services on Weight Watchers international websites encourage providing personal data, sometimes health-related, in an effort to personalize a weight loss journey. But a lawsuit alleges that WW International provided that data and other identifiable information to third parties despite promises in its privacy policy. Joining me is an expert in cybersecurity and data privacy, Collin Walke, a partner at Hall Estill. So, Collin, what kind of information did Weight Watchers allegedly give out and how?
So, Weight Watchers was able to give out this information utilizing pixels that were on their website from companies like Facebook/Meta, or Google, for analytics purposes. And their allegations are that essentially every question that you answered on their website, up to and including, are you living with type 2 diabetes? Have you used any weight loss medication? Do you have a history of cancer, blood pressure, all of these sorts of sensitive information, low testosterone? All of these questions were questions that you were supposed to answer when you went to the website that had these pixels on them and shared that information then with third parties.
The sharing with third parties was deliberate, or was it a mistake?
Well, it appears that it was deliberate. I mean, according to the allegations, certainly Weight Watchers knew about utilizing pixels in relation to healthcare information because the Federal Trade Commission has issued warnings to that. And in fact, Weight Watchers was sued once before regarding these types of issues. And so Weight Watchers knew that pixels were being utilized and continued to do so in spite of warnings from the Federal Trade Commission. So, for example, like Fitbit, it collects healthcare information, but it's not a HIPAA-protected entity, and so they can do whatever they want with that information. And so consequently, the FTC came out and said, no, you need to start treating healthcare information wildly different than any other type of information and protect it better, i.e. don't use pixels on websites.
They had a privacy policy, right? And they pledged that they wouldn't share the information without written consent?
That's correct, but you have to, read between the lines on their privacy policy because they do note that they share this information with third parties. And that's part of the problem with privacy policies. One, if you actually took the time to read all of them, you would never actually utilize a website. You'd just be reading all of these vague details. And then two, because there aren't requirements on what privacy policies have to contain with certain nominal exceptions, they can get away with making broad statements like, we don't sell or share your data to third parties, And at the same time, they can still do it because they'll share that information for marketing purposes or other sorts of quote-unquote internal business purposes. And so if you're utilizing the information for internal business purposes, i.e. analytics, then you can get away with sharing this type of information with third parties. So it's really all about wordsmithing.
They're suing them for exactly what?
Yeah, so for several different violations. One, there's a couple of state law claims involved in this, as well as unjust enrichment because you're taking individual private information and then profiting off of it. They've included a claim for intrusion upon seclusion, which is a common law claim, a violation of the California Code as well as the New York General Business Code, and violations of the Electronic Communications Privacy Act. So they have 2 or 3 common law claims and 2 statutory.
Weight Watchers is reportedly facing bankruptcy. If it does go into bankruptcy, what happens with the data?
So that's all part of the question, right? So first and foremost, this class action lawsuit filed against Weight Watchers was filed on April 9th. So they're still at the beginning stages, and in fact, I do not believe that Weight Watchers has answered yet. If it's the case that Weight Watchers is in fact going to file for bankruptcy, the question becomes, is it going to be like a 23andMe situation in which they're looking for buyers, i.e. a Chapter 7 or something along those lines? Or is it going to be something more like a Chapter 11 where it's a true restructuring, in which case Weight Watchers wouldn't necessarily sell or give away this information to any third parties, but would retain it for their future use, after they've addressed all of their debt issues. But all that said, it goes right back to what we saw with 23andMe filing bankruptcy, which is if it's the case that they go ahead and liquidate the company, these are assets, which is part of the reason why the plaintiff sued for unjust enrichment. And this is the private type of information that's going to be sold in a bankruptcy proceeding.
So you can go on these sites and they give you options about whether you want to share your information or not. Does any of that matter in reality?
Well, so you've got to remember there's a slight difference between, for example, accepting cookies, right, or rejecting cookies, which is one way that they can obtain your information. But anytime you fill out a form, the form and that information is going to be stored with that company. And so even if you opt out of all cookies, you might still be consenting to them utilizing this information because, remember, all state laws at this stage are opt-out, and with the exception of Colorado, which has a minor exception for sensitive information. But otherwise, these are all opt-out statuses. And what that means is while you may decline cookies, once you've submitted your information to that company, they can basically do anything that they want with that information, up to and including selling it to third parties.
So then as you respond to the questions or fill out forms, you should just consider that information is gone, whatever information I'm giving them.
I don't think that most consumers realize how unprotected their data is. Once you go on the internet and you interact with a third party, for all intents and purposes, that information is then going to be retained by them. And they can pretty much do whatever they want with it. And so the concept of privacy no longer exists because we have divided human beings from their data. But the reality is human beings are data. What we do on a daily basis is being collected. And so consequently, we need to make sure, or we need to try and obtain rights to our data, not just privacy laws and those sorts of things, but actual rights. Because then if, for example, Weight Watchers says we don't sell your information or give it away to third parties, and Meta gets hacked, and all of a sudden you find out that they've got Weight Watchers information in their website, you now have a claim, plain and simple, because they stole your property and used it without your consent. But right now, there are no laws on the books, even except for a few minor exceptions, that say your data is yours. Otherwise, your data is whoever you give it to.
So then it would take a law to change this.
That's correct. So, for example, in Oklahoma, and this is the only law that I'm aware of on the books, but I would love to see it in other states. In Oklahoma, there's a law that says if you upload healthcare information to Oklahoma's Health Information Exchange, which is a database that most states have, where if you get injured in one part of the state, a doctor in another part of the state can look up that information in the Health Information Exchange. And the law says that all of the information and data that you upload to the Health Information Exchange, you, quote, retain a property right in that healthcare data, but then give them a license to use it. So there is a statutory instantiation of your property rights in your healthcare data. Now, how far does that extend? Probably not much further than your healthcare data, but you can see how we would be able to pass a law that would cover any type of data that you give over to third parties.
So a few months ago, I got a notice that a company had been hacked, and it was a company that was somehow involved in processing claims for one of my doctors. So you're giving information to your doctors, and somehow that information is getting hacked?
So that's another great example. So within HIPAA, there are rules that permit third parties to utilize this data on behalf of the covered entity. So, for example, your doctor, he gives this over to a third party so that they can essentially manage it but not utilize it without his permission. Here's the problem, is that I would be shocked and astounded whether many, if any, healthcare entities actually then go to their business associates and vet their cybersecurity protocols. Instead, the business associate agreements typically say that, you're going to comply with HIPAA and you're going to comply with my instructions, but there's no verification, there's no auditing that, in fact, that's what they're doing with that data. And in the healthcare space, it is all over the place because you're sharing information with testing facilities, with third-party billing companies. So your data gets spread all over the place, and you're hoping and praying that somebody's actually going to comply with that business associate agreement.
And their solution is usually to give you something like a year of free credit monitoring. But what can you do? You really don't have a choice but giving information in some of these situations.
That's a very good point. And not only that, but what are you going to do about the data breaches themselves? I mean, in HIPAA, if somebody is breached and less than 500 healthcare records are accessed, the reporting entity does not have to report that hack until February 1 of the following year. So you as a consumer, how are you going to protect yourself when you find out about this hack a year later? You're not. And in fact, I've been an advocate that we need to rethink our breach notification laws altogether because just like you said, what do you do when you get that piece of paper? You throw it away or you call a credit agency to monitor your credit. That's about all that you can do at the moment. There needs to be more meat on the bones when it comes to data breach notification requirements.
And for a moment, I want to turn to the issue of DOJ accessing personal data of Americans. I was surprised an appeals court, I think it was last week, cleared the way for DOJ to access people's private data at 3 federal agencies. And then on Friday, a Manhattan judge said that one member of DOJ could have access to sensitive payment and data systems at the Treasury Department. I mean, this is another case of information that you have no control over that the government has.
Absolutely. And it's not just information that you've supplied through, for example, Social Security information and those sorts of things, but it's all of that information plus whatever else that the government can aggregate from data brokers, which they have full reign and free access to just by asking the data brokers to give them copies of that information. And so it is very concerning, especially when you have individuals that haven't necessarily been vetted through proper credentialing and background checks and those sorts of things. But that's the problem is how much are we going to trust our government? Whether that's a Democrat sitting in there or a Republican, how much do we want to trust them with our data? And just think about it this way. Every time that you go to the airport, you have that bioinformation screen face check when you go to check in. That information is then stored and utilized so that, for example, if you're in New York City and there's a street camera that can pick you up, they can then re-identify you fairly quickly. And not just that, but your gait. All sorts of unique aspects about you are stored not just by third parties, but by the government as well. The thing is that I do not think that people appreciate the surveillance state that we live in at the particular moment. If we want to identify any particular person in the United States right now at this moment and where they're at, if they have a cell phone, we can do that fairly easily.
So you mean that all the TV shows and movies that show a law enforcement agency tracking someone's every move are true?
It is. Unfortunately, it's a very scary situation in which we're living in front of. I mean, for example, one of the questions on Weight Watchers was, have you made yourself vomit within the past week? Well, you could imagine then that information being sold to some diet pill company who then sends a targeted ad towards you, and now you're getting, fluff medication from some third party that probably doesn't work as opposed to from your actual healthcare provider. And so it's really concerning how we're giving away this information and how it can be utilized.
So what do you do when a website asks for your information?
So, again, it's all about risk. And so certain websites I have to use, but I will tell you, I don't use apps on my phone at all. I have like 5 apps that didn't come pre-stored. And it's because I'm more concerned about them tracking me on my phone and where I'm at more so than necessarily what I'm uploading to the website. Because the reality is we live in a world in which we have to upload information to websites every day. So it's a matter of managing your risk.
So then when you check "Don't follow me," that doesn't work?
Well, it can. It can to some degree, but you just never know. I mean, there's a lot of back doors, and so I just prefer not to even risk it.
So I guess the only solution is to go back to an analog world.
I think that's the way people are going to realize they need to be safe. Yes.
Whenever I talk to you, Collin, I make a pledge to be more careful about my data. Not that it can help much, but thanks for the warnings. That's Collin Walke of Hall Estill. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.